Lord Hewart, quote, "My Lords, may I in a word or two join in the thanks which are being offered to the Lord Chancellor for the wise withdrawal of this clause. In the events which have happened, it is not necessary that I should refer even in a word to the feelings which the clause excited in the minds of His Majesty's judges of the King's Bench Division. It was without exception the worst clause of its kind which has ever appeared. I say that having in mind Section 29 of the Local Government Act of 1888 and Section 70 of the Local Government Act of 1894. The first of those sections led to two abortive decisions which were afterwards overruled. This was a proposal to convert His Majesty's judges into departmental solicitors. I am glad that the proposal has been withdrawn, and as it has been withdrawn, I would venture to hope that the Lord Chancellor may now turn his mind to the many cases in the past, I hope there are not going to be many cases in the future, in which a different method is employed, I do not say by a hidden hand, but what is obviously a concerted endeavour to subtract from the law courts important decisions, and to get those decisions made behind the backs of the parties interested by a department or a departmental committee. I join in the congratulations which have been offered, and in the circumstances refrain from saying much that otherwise I should have had to say." End quote. Lord Carson, in the passage cited above from his speech in committee on the bill, referred to his earlier speech delivered in the House in the course of the debate on the second reading, 27th March 1928. That speech dealt so forcibly with more than one matter closely connected with the present inquiry that it seems convenient to reproduce part of it here. Lord Carson, quote, "I certainly wish to take the first opportunity that I have of speaking on this bill to enter my absolute protest against Clause 4 as at present framed. I am not at all surprised to be told that a vast number of questions have arisen for legal decision under the Act of 1925, because it was pointed out, when that Act was before this House, that it was full of many difficulties and some absurdities, and we were only given a day or two in which to pass it. Otherwise, we were told, the Constitution would tumble over and the House of Lords would forever cease to exist. We accepted the situation, as we always do at the end of a session with a Conservative government in power. Therefore, I am not at all surprised to be told that there are these objections, and that they must be got rid of in some kind of way. For the sake of uniformity, and I have no doubt with very good intentions, somebody hit upon Clause 4. If somebody would invent an easy way of having matters decided in the courts of law without the expense that now occurs, I should be the very first to support him. But if there is one matter above all others that this House ought to take care that the government should not be allowed to do, it is that they should not be allowed to take from litigants the right of decision by the courts and the right to argue their cases before them. That is what this clause does. I do not know why there is this passion recently for either setting up autocratic bodies within a department or setting up tribunals ad hoc, which now is the fashionable way. Only a few months ago the Landlord and Tenant Bill was before us. They tried, and this House did something to prevent it, to take away certain matters entirely from the courts of law by that bill, which left a great deal for the judiciary to legislate upon. The result has been that agents and solicitors and people concerned are all warning everybody that they ought to have no transactions under the Act until the meanings are explained by the courts. Now the government wants to get over that sort of difficulty by simply saying that the Central Valuation Committee may go to the Minister of Health, show there is a very great question of law with regard to the rating of hereditaments, or a class of hereditaments, for decision, and to ask him to take the case up to the courts and have it decided. In the old days, as I understood, and I had some experience as a law officer, if in framing your bill you had any doubt about it, you sent it to the law officers, and the government had the care and responsibility for their own legislation. But now what you are to do is this. You are, without having any concrete case or parties before you, to go to the courts and ask for their opinion. When that opinion is given, I am not sure what is to happen. It does not say in the clause. All it says is that the High Court, after hearing such parties as it thinks proper, shall give its opinion on the question. Is that opinion to affect people who have not been heard? Is it to affect a number of people who may come within a certain class, but who may think they may have entirely different rights? If not, of what value is it? If it is a mere departmental matter to help the department, then probably there is not very much harm in it. But does it mean that when John Jones, the friend to whom the noble lord opposite referred, has a case to be considered, and goes up before the court, he is to be told that there is already a decision which has been given? He will say, "When was it made? Why was I not given notice of it?" Of course, they cannot give everybody notice of what is going to affect people upon these decisions being taken by the High Court. Who is to state the case? I suppose the Central Valuation Committee. Who is to agree the facts, and the deductions from the facts? It is all to be stated behind the backs of the ratepayers. It may be a very convenient thing for a government to be able to come forward when a ratepayer objects and to say, "Oh, you cannot do anything more, this is all closed. On such and such a morning we went before the Lord Chief Justice and one of his colleagues in the King's Bench Division, and it is all completely settled." "But," he says, "I did not know anything about it." "Well," is the reply, "you ought to have known, because everybody is presumed to know the law, and the law has been settled by this court." Who is to settle the case? And then, if the Central Valuation Committee do not like the decision of the court, are they to be able to go to the Court of Appeal? Are they to be able to go to the House of Lords? There is nothing about that in the bill. The Minister may submit the question to the High Court for its opinion thereon, but how much further the matter goes I do not know. This, to my mind, is the very worst kind of legislation you could have in the interest of the subject. I cannot discuss it now, because it will have to come on as a committee matter, and I am only discussing it in general outline. But I do beg of noble lords to go into the question and be prepared when the matter comes up in the committee. There is no reason in the world, if this is allowed to be the way of deciding questions, why exactly similar provisions should not be put into finance bills. The commissioners of taxes might say, where we are assessing cases of excess profits, we often have great difficulty. Why not put in a clause in such cases providing that all you have to do is to state a case for the High Court? I look with great apprehension on a clause like this, which, if put into Finance Acts, would take away from the taxpayer the right which he now has to challenge an assessment, which would then not be based on a general principle that may have been sanctioned by the court. However, I have no intention whatever of opposing the bill, which may or may not be useful. I will take that assurance from my noble and learned friend who moved the second reading, but I do hope that by the time the bill comes on in committee, noble lords will have taken some trouble to instruct themselves upon the far-reaching consequences of this legislation." End quote. The clause accordingly perished and the particular attempt failed, but nothing can diminish the significance of the fact that the attempt was made. Hardly less significant was the memorable speech in which Lord Salisbury, speaking as Lord Privy Seal, endeavoured to cover the retreat of the government. The speech was brief, it was a matchless revelation, it ought to become a locus classicus. Here it is in full. The Lord Privy Seal, the Marquess of Salisbury, quote, "My Lords, I do not intend to take part in a debate which has been entirely confined up to now to lawyers, except to say that I do think lawyers might sometimes consider the interest of suitors. Here is a provision put into the bill with the object of saving expense to unfortunate ratepayers, and the only thing which the great lawyers can think of is whether some special theory of law and of administration is complied with, and they do not think of those interests which are so acutely felt by the suitors. I do not contend for a moment that the noble and learned lords are not right in their contention. They probably are. They know far more about it than I do, but I do say it is a most singular circumstance how very difficult it is for poor people to get justice in this country because they cannot really afford it on account of the enormous expense. The expense is growing every day, and the result is, I am quite sure, that there is a great failure of justice to the suitor. Whether that is unavoidable I cannot say. It may be so, but I do wish, when great judges address themselves to your lordships on this subject, that they would take into consideration that side of the case." End quote. The conclusion appears to be irresistible. It looks as if somebody, who can it have been, had told Lord Salisbury, and he had believed the statement, that it is to the interest of poor people to have their causes decided behind their backs, upon hypotheses formulated in advance by the opposite side. A clause of this kind was not entirely novel, but previous experience ought at least to have served as a warning. Section 29 of the Local Government Act 1888 had provided as follows, quote, "If any question arises, or is about to arise, as to whether any business, power, duty, or liability is or is not transferred to any county council or joint committee under this Act, that question, without prejudice to any other mode of trying it, may, on the application of a chairman of quarter sessions, or of the county council, committee, or other local authority concerned, be submitted for decision to the High Court of Justice in such summary manner as, subject to any rules of court, may be directed by the court, and the court, after hearing such parties and taking such evidence, if any, as it thinks just, shall decide the question." End quote. The sequel was extremely interesting. Recourse was had to the machinery provided by this section in two cases, one in 1891, the other in 1894. The cases, reported in the law reports, are ex parte County Council of Kent and Council of Dover, ex parte County Council of Kent and Council of Sandwich, 1891, 1 Queen's Bench 389, and in Re County Council of Herefordshire and Town Council of the Borough of Leominster, 1895, 1 Queen's Bench 43. In the former case, Mr. Justice Vaughan Williams, as he then was, giving judgment, said, at page 399, quote, "We hope that the principle upon which these answers are given sufficiently appears. We may in some cases have been mistaken, owing to the exact facts not having been brought to our notice." End quote. The remark was prophetic. In 1898, the decision in both cases was overruled in Thetford Corporation v. Norfolk County Council, 1898, 2 Queen's Bench 468. Giving judgment in the Court of Appeal in this later case, which was a real, not a hypothetical case, Lord Justice Vaughan Williams said at page 483 that he was fully satisfied that his previous decision was wrong, and that he had put a construction upon the material sections which I am now satisfied they will not bear. Yet this expensive lesson seems to have been thrown away. End of chapter 7.